Thanks very much, Alex. My name's Richard Kemp. I spend my working life around the legal aspects of data, software, and services. Today, I'm looking at big data and the cloud. In terms of the legal analysis of these two areas, the sort of initial impression is that they're pretty big and they're pretty scary. And the first thing to do is to try and put some sort of order in terms of a legal analytical framework around them. So what I'll do is look briefly at big data and try and give you an overview of the legal issues around that. And then similarly with the cloud, and then put the two together and kind of see where we get to. So the first thing is to try and get to some sort of analytical framework in legal terms as to what big data is all about. And this slide here has this sort of kind of 6-layer stack. At the bottom of it, you've got legal issues around platforms and infrastructure. And this is sort of, in legal terms, software look and feel mainly, but you're looking at the legal aspects of the kit, the equipment, the routers, the computers, and the various strata of software from the operating system up through middleware and into business intelligence and analytics software in the case of big data. Above that, you've got the legals around the data architecture. That's something that tends to get quite overlooked. If in your big data project you're working to a particular data architecture, there are legals around the copyright in the structure of the schemas, the copyright in the structure of the architecture more generally. And then the next 3 levels are really what I get particularly involved in. And they're the legals around the data itself. And they come in 3 flavors. Contracting. In the big data world, in any data world, contract tends to be king. If you look at market data in the financial services industry, which is a $25 billion global industry, then that works on a contractual ecosystem. And it just works through the power of contracts. Above that, you get IPR, intellectual property in data, and that's an area that's developing really rapidly at the moment around copyright, database, confidentiality in particular. And in this area, over hundreds of years, the law has tended to follow the money. If you look at the copyright industries, they've grown up with advances in technology, and then copyright has kind of rushed in like Lego. Bits keep getting added to it to give sort of comprehensive legal protection over time. So, and that's a particularly vibrant area at the moment. There's a lot of legal development around what IP-type rights reside in relation to data. Copyright, database right, confidentiality. And then above that, you've got regulation. So you've got this sort of triptych, if you like, of contract, intellectual property, and regulation in relation to data. And regulation is another area that's growing particularly quickly. We'll look at data protection, which is the best known and probably the broadest in relation to both big data and the cloud. But you've also got sector-specific regulation. You've got the regulator wants to know how big data is affecting the companies that he regulates. And then you've got sort of data sovereignty. And again, all these things are particularly vibrant at the moment. Because such a lot of money's been poured into big data, the law is racing hard, as it ever does, to catch up with these technological developments. And then on the top, the 6th stack at the top is in information management and security. Tends to be around standards, 27,000, all that sort of stuff. But again, another sort of, not I would say a legal minefield, but an area that's kind of legally charged. So, and that's really the framework for big data. If you've got a big data project, it sort of helps to keep that in mind. So if you look at the way big data tends to come into the organization, you've got input, processing, and output. On input, you want to make sure that you've cleared all the rights to the data that you're getting in. If you buy it in from a structured source, that's probably going to be relatively easy, although you may have limitations of use as to what you can do with it. Similarly, where it's processed, that's more a question of the BIA software that you're using. And then output, you need to make sure that the data that you're outputting, you've got the rights to send it to the places that it's going. So The point here really is to try and say, look, it's not that scary. There's quite a lot to think about. Each of these layers are big areas in legal terms, but it is sort of manageable. Now, the thing that everybody knows about and gets most attention is privacy, is data protection. And that's both in relation to the cloud, which we'll look at, and in relation to big data. And I'm sure you're all aware of the sorts of big data issues that arise in relation to privacy. Insurance is probably the biggest area. If you have certain genetic predispositions, it might make life insurance more difficult or to obtain or unobtainable. Equally, if you look at sort of wearables and home sensors, domestic and personal insurance, and in the motor car, if you have a crash, onboard telematics and location-based services can say whether you were where you said you were at the time of the accident and whether you were driving safely. So not surprisingly, this is all around personal data, information about identifiable individuals, and again, this is getting more and more press. So that's big data, that's sort of step one. And then as you put your big data into the cloud, whether it's sort of on demand at Christmas or any other time, whether you're hybridizing it, whether you're just sort of extending your own big data operations, there are a bunch of legal issues around the cloud. And again, I won't go into these in detail. And they're reasonably intuitive. Again, there are quite a lot of them, which is what tends to make it a little bit scary. But if you analyze it down, then again, they come in a framework. So if you're contracting with the cloud, you'll have a contract with the cloud provider. And the key mismatch there is that the importance of the service, the cloud service that you're getting, may be disproportionate to the amount that you're paying for the service. The payments may be quite low, which is one of the key benefits of the cloud, but the importance to you of that data is really significant. So these tensions tend to get mediated in the liability clause, and market practice is that there's either a service level agreement which restricts the amounts of the outage payments that the provider's paying, or there's some sort of cap on liability limited to maybe 12 months payments. And if the payments are quite low, that may not remedy your breach adequately. So there is a certain amount of tension in the cloud in contractual terms. That tension's probably not going to go away. You may be able to pay a bit more for a slightly higher risk being taken by the provider, but it's all around the practical, technical, and operational steps that you take to balance that risk. There isn't actually that much IP stuff in the cloud. Cloud providers generally don't want to take your IP, the IP and the data that you put with them, and they're normally, as you'd expect, pretty relaxed about that. But as we see from the press, there's a lot of regulatory activity going on in the cloud. Sometimes you don't have any paper you pick up has got iCloud, it's got Snowden, it's got Patriot Act, it's got Microsoft in Dublin, it's got the spooks, it's got all this stuff. So this area of data sovereignty is particularly charged at the moment. I try and take a kind of irrational approach to this, which is you're dealing with incredibly basic powers of the state here. They've always been here. 200 years ago, they were exercised in relation to goods coming in across the ship's rail and all that sort of stuff. And the answer is probably to sort of let your customers know, if you're using a cloud service, of the circumstances where your data held in the cloud can be nicked or looked at. Again, sector-specific regulation is particularly important. In my area, my regulator is the Solicitors Regulation Authority, and under the SRA Code of Conduct, which all solicitors firms have to follow, there's a thing called Outcome 7.10, which says that if the SRA comes knocking on your door, you have to either be able to take them along to the data center, or give them a copy of the data, or give them a copy of the records. Now, how likely is that? So you've got this slightly unreal world where the data knows he's not going to go along to a data center, which is probably going to be in the UK or at least in the EU, and the cloud provider knows he's not going to come too. So you've got quite a few things dynamically being worked out at the moment. Same's true with the Financial Conduct Authority and Sysgate, which is, for those of you in the financial services and insurance world, you'll know that Sysgate, System and Controls, Chapter 8, puts sort of requirements on you in relation to material outsourcing. Generally, just what a sensible outsourcing agreement should say. So a bunch of legal issues relating to big data, a bunch of legal issues relating to the cloud. And when you come to put them together, the thing that leaps out at you first is data protection. So this is the Data Protection Act. You've got, again, the law is going through this difficult transition at the moment with all the discussions in Brussels around the new draft General Data Protection Regulation. But at root, data protection is all around fair processing, fairness, transparency, openness, what the data subject, the person whose personal data it is, can reasonably expect. And that's at odds with big data. Big data is all about finding previously unexpected correlations between different data sets. So how do you balance that, the collision, if you like, between the bigness of big data and its propensity to give you unexpected correlations and the requirement for fair processing? The UK regulator, the Information Commissioner, came out at the end of July with a useful paper which is on their website about big data and data protection. And what they first do is they go through all these issues. So you've got fair processing. The second one is consent. Now, consent needs to be understood. It's got to be explicit. It's got to be definite. It's got to be made by each data subject. And it's got to be appropriate. And appropriate means that the data subject can withdraw their consent. So if you are using big data analytics and big data and you're relying on a customer's consent to what you're doing, then do bear in mind that that consent can be withdrawn. So is it therefore appropriate that you should rely on consent in those circumstances if you've got very big data operations? Another thing is purpose limitation. Now, the personal data lawfully collected for one purpose mustn't be used for a purpose that's incompatible with the first purpose without further consent. So you're going to see a lot of development about this issue of compatibility. And that takes you into where you're providing a service in relation to which big data operations are used. What do you mean by an incompatible purpose? And it goes to the sort of, is the purpose intrinsic to the service? So you're going to see a lot of development around what purposes are intrinsic to a particular service. Another area where big data and data protection collide is data minimization. In the cloud, or in big data, whether it's in the cloud or on-premise, n equals all. You want to get absolutely all the data you can scour out and then analyze all of it. But under data protection law, personal data has got to be adequate, relevant, and not excessive, and kept for no longer than necessary. So this sort of proportionality tends to data minimization in data protection law land. But in big data land, n equals all. You want vast, the bigger the data sets analyzed, the better. So that's in big data. You take it out to the cloud, you've got a whole bunch of other issues as well. Is your provider acting as a data controller or as a data processor? Is he acting under your instructions only, in which case he's likely to be a data processor, or are they carrying out activities themselves? Where is the data stored, or where is the cloud service stored? Where's the data center that you're using for the big data concerned? If it goes outside the EU, you've got issues, particularly where it goes to the States or otherwise, around safe harbor, the EU's model clauses. Are you getting binding corporate rules? if even within the EU, as we've seen with Microsoft's data center in Dublin, you've got Uncle Sam trying to get access. And this was a slightly unusual case because it was in the context of a drugs criminal trial in the States. But you do have Uncle Sam trying to get access to data that Microsoft stored in Dublin. And then this issue of data sovereignty, which is high on everyone's agenda at the moment and generating more heat than light. So in data protection land, you have lots of issues around big data and particularly big data in the cloud. Now, the way of addressing these is set out to an extent in ICO's Big Data and Data Protection Report of July. You need to consider getting consent, the right consent to the right processing at the right time. In the States, they're much more concerned about sort of notice and consent. But again, transparency and notice are particularly important over here. Anonymization is another big subject in relation to big data, whether it's in the cloud or on-premise. And one of the difficulties here is that as the amount of data grows exponentially, so the correlations that enable one bit of data to become personal data and hence subject to all these data protection rules becomes much bigger as the world of data expands. And there are a number of sort of non-legal type ways of addressing it, building trust. Not only can we do this, but should we be doing it? Is it what consumers reasonably expect? ICO is big on privacy impact assessments, sort of setting out in a structured way before you do or as you're doing your big data and cloud project, what's the impact of this going to be on personal data, and how do we balance the risks and the benefits and make sure that data subjects' rights are protected. And this kind of fairly neatly segues into information governance, which in the real world and as a practical matter, I think, is the answer to a lot of big data and cloud issues. A structured approach to understand the data sources, understand the types and uses that the data is being put to. And Forrester came out with a report last year about data zones. Okay, you should analyze what types of data that you've had, and at the high end where it's really important, the use and control around that data can be really structured. And at the other end of the spectrum, you can have what they call chaotic, which is stuff that you don't really care about, but you don't need to spend a lot of time worrying about it. And that kind of leads on to the last slide, which is just to look in a little bit more detail around information governance. And this sort of follows a kind of classic structured approach, which you may have seen in relation to data protection or open source or IP-based things. But the first thing is a risk assessment. What are we doing at the moment? What are we doing wrong? How do we fix it? The second step is a sort of strategy statement, kind of high-level statement of what the organization wants out of big data and cloud, and get buy-in from all stakeholders, and a really high-level statement of where we want to be. It's stuff like, we respect other people's IP rights and regulatory responsibilities, just as we expect other people to respect ours. And then the policy statement, which is basically, in my experience, a kind of project plan of what we're going to do with timelines, dependencies, budgets, the sort of who does what. And then at the fourth level, you've got detail around sort of policies and processes and how we're going to get there. So in a kind of practical sense, the way that the organization can manage big data and its sort of extension to the cloud ends up being through information governance, following these steps. But to get there, you sort of have to have this analytical framework in your head about big data and about what happens when you put out to the cloud. Now, I think we're going to be taking some questions now if anyone has them. So over to you, Alex.